Colorado wet floor sign law. Wet floors can lead to serious injuries in the event of a slip and fall. For this reason, Colorado law requires property owners who invite the public into their facilities to maintain safe conditions or warn the public of potential dangers. Whether you can hold a property owner liable for a slip and fall accident depends upon the relationship between the parties and whether you can prove the owner failed to take reasonable steps to prevent an accident. A wet floor sign in many cases can affect whether you were reasonably made aware of a dangerous condition and whether you can recover financial compensation. Understanding Colorado's wet floor sign law. Colorado's wet floor sign law serves as a crucial safeguard against slip and fall accidents, which can result in severe injuries and legal liabilities. Colorado law does not explicitly require property owners, businesses, or other entities with control over property to use wet floor signs. Instead, Colorado requires property owners and operators to consider the circumstances and their duty to the people invited into their property. Wet floor signs are generally a legal requirement in Colorado when reasonably necessary to protect visitors, workers and other people from wet and slick floor hazards. If conditions could reasonably result in injuries to those people, such as rain, snow, spilled liquids, or leaking equipment, the business or other party in control of the property has a legal duty to display wet floor signs. Failure to display signs under these circumstances could create legal liability for a slip and fall accident causing injuries. Key requirements of Colorado's wet floor sign law. Prominently visible signage. Property owners or managers must display highly visible wet floor signs in areas where the floor is wet or slippery due to cleaning, spills, or maintenance. Warning messages. The wet floor signs should include clear and concise warning messages, such as, caution, wet floor, or slippery surface ahead. Strategic placement. Wet floor signs must be strategically placed in areas that are easily noticeable and visible to anyone approaching the potentially hazardous zone. Timely placement and removal. Wet floor signs should be promptly set up as soon as the floor becomes wet or slippery, and they must be removed once the floor is dry and safe to walk on again. Does a wet floor sign change the legal duty of care in a slip and fall case under Colorado law? Wet floor signs play a significant role in slip and fall cases, but it is crucial to understand that they do not absolve property owners of their legal duty of care. Contrary to popular belief, merely putting up a wet floor sign does not necessarily mean the property owner has taken all necessary precautions to prevent accidents. In Colorado, all property owners are required to exercise a level of care that a prudent landowner would demonstrate under similar circumstances. If a prudent person would take additional measures beyond just using a wet floor sign, the property owner can still be held liable for slip and fall incidents. However, it is important to note that the presence of a wet floor sign can impact the legal duty of care owed to visitors. Previous case law, such as Matthias v. Denver Union Terminal Rye Company, establishes that a visitor's status may change from invitee to licensee or even trespasser if they walk behind a wet floor sign. This change in visitor classification subsequently alters the property owner's legal responsibilities. Therefore, it is crucial to be aware of your visitor status, both with and without a wet floor sign, to determine whether you have the right to pursue a slip and fall claim. How a wet floor sign might affect your premises liability case. To establish a successful claim, you must demonstrate that the property owner, company, or employee breached their duty of care and that this breach caused your slip and fall accident. Generally, a property owner's duties of care encompass the following: inspecting the premises for new or undiscovered hazards, including wet floors. Addressing the defect, issue, or hazard within a reasonable time frame. Warning visitors about existing injury risks on the property. While putting up a wet floor sign is a part of fulfilling the property owner's duty of care towards invitees, it may result in a lesser duty of care if you transition from an invitee to a licensee by walking past the sign. Even if the property owner fulfills their duty of care by using a wet floor sign, you may still have grounds to file a claim if the sign proves to be an ineffective warning. Seek advice from a qualified slip and fall accident attorney. Slip and fall liability cases encompass various aspects, and the presence or absence of a wet floor sign is just one factor that can impact your claim. If you have recently been injured in a slip and fall accident in Colorado, seeking guidance from an attorney is highly recommended. An experienced attorney can assist you in identifying the responsible party and handling settlement negotiations with insurance companies on your behalf.